Very warm and a hearty welcome to each and every one of you from the entire team at BYJU'S Exam Prep. A very good evening to all of you friends. Welcome to Maharashtra CET Law 2023, a marathon on legal aptitude. So guys, those of you who are preparing for Maharashtra CET, SLAT, JMI Law, and other law entrance examination for the year 2023, this particular session will be of great importance to each and every one of you. So in this session, I shall be discussing some approximately around 40 questions, to be precise 39 questions with you. Now these sessions are aimed so that you can perform better insofar as your Maharashtra CET exam is concerned, your SLAT exam is concerned, as well as your JMI Law entrance examination is concerned. So a very warm welcome to all of you. A very good evening to all of you. Okay, I can see some people who have already joined in. Okay, fantastic. But I would request that before I start my session, please share this session with your friends so that more and more students can join in and be helped from this particular session. So guys, let's get going. So, but before we begin, BYJU'S Exam Prep brings to you a free workshop on why choose CLAT as a career. So if you are preparing for 2024 CLAT, next year CLAT, the CLAT is going to be scheduled this year in the month of December. If you are planning for December 2023 CLAT, please join this session, which will be conducted by Nivedita Raje on why choose CLAT as a career option. This is scheduled on 9th of April at 6 p.m. So hurry up and register now for this free workshop. BYJU'S Exam Prep brings to you a CLAT 2024 comprehensive course. In this particular course, we are going to provide you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis of the past 5 years of CLAT question paper. So hurry up and register for CLAT 2024 comprehensive course from BYJU'S Exam Prep. So guys, before I begin with the questions, now insofar as your Maharashtra CET examination is concerned, just wait for a minute. Now your Maharashtra CET exam is concerned, your SLAT exam is concerned, your JMI exam is concerned, there are 2 types of questions that come. One is legal knowledge based question and the other one is principle and fact based question. Now, of late, CLAT has moved forward from principle and fact-based question to passage-based question. But JMI LAW, your Maharashtra CET, your SLAT, they even today ask questions relating to your legal knowledge and your legal reasoning, that is principle and fact-based question. So today I am going to discuss with you some very important both legal knowledge questions as well as principle and fact-based question. So guys, let's start reading. The Supreme Court, question number 1, the Supreme Court's landmark judgment, which is known as Indira Sahane versus Union of India, is also known as what? Is it known as the Ayodhya judgment? Is it known as the Election Commission judgment? Is it known as the Euthanasia judgment? Or is it known as the Mandal Commission judgment? The Constitution Bench of the Supreme Court of India in Indira Sahane held that reservation cannot exceed 50%. Very important. And the Mandal Commission dealt with reservations of the backward classes of people. So Indra Sahane judgment is popularly known as the Mandal Commission judgment. Am I clear? All of you? Is that clear? Okay, Sambhavi, we will have a class on constitution. Okay, don't worry. Okay, fantastic. So option D is the right answer. Okay, moving on. The first Attorney General of India. The first Attorney General of India. C.K. Daftari, Nani Palkiwala, M.C.CET Law, or none of the above. Now, C.K. Daftari was the first Solicitor General of India. And he was the second Attorney General of India. Very, very important. C.K. Daftari was the first Solicitor General of India and the second Attorney General of India. Mr. Nani Palkiwala was never the Attorney General of India. But the correct answer is M.C.CET Law. M.C.CET Law was the first Attorney General of India. Very important question. So the option is C. Is that clear? Okay, all of you. Who is the present Attorney General of India? Please give me the answer. Who is the present Attorney General of India? The present Attorney General of India. Fast. So who is the present Attorney General of India? Fast. Very good. Mr. R. Venkat Ramani. Mr. R. Venkat Ramani is the present Attorney General for India. Okay? Yeah. Moving ahead. Good. Question number 3. Which union territory has a high court of its own? Chandigarh has a high court. Punjab and Haryana. Delhi, Andaman and Nicobar. Andaman and Nicobar has its high court is the Calcutta High Court. But the Union Territory of Delhi has its own high court. So the correct answer is option B. Which union territory in India has its own high court? It is Delhi. Delhi has its own high court. Now Punjab and Haryana High Court is situated in Chandigarh, but Chandigarh does not have its own high court. Andaman Nicobar does not have a high court of its own. The jurisdiction of Andaman Nicobar is Calcutta High Court. Am I clear, all of you? Is that clear, everyone? Fantastic. So you guys know a lot of legal knowledge questions, so keep these things in mind. Question number 4. How many persons are required to constitute the offense of conspiracy? 5, 7, 2, none of the above. How many people are required to constitute the offense of conspiracy? Please tell me the answer. 5, 7, 2. Now the law says when 2 or more than 2 people, very, very important, at least 2, minimum, when 2 or more people. Now you cannot conspire with yourself. At least you require another person to conspire, right? To commit the offense of conspiracy, you cannot commit a conspiracy with your own self, right? You at least require another person. So the correct answer is option 2. 2 is the right answer. Am I clear, everyone? Have I made myself clear? Okay, good. So you guys are enjoying this session? You guys are understanding how to solve these questions? Good. Moving on to question number 5. The person who make an affidavit. Now, what is an affidavit? You are making a statement in a court and you say that I swear that the statement that I am making is true to the best of my knowledge and ability. So to the best of your knowledge and ability, you are making a particular statement before the court. Am I clear? So if you are making a statement before a court, you are making a particular statement before a court which is true to the best of your knowledge and ability. That is called an affidavit. Now, the person who is making that affidavit, what is he called? Is he called an author? Is he called an deponent? Is he called an affidavit? Or none of the above? Please tell me the correct answer. Very important. He is called the deponent. Harsh Maurya. Very good. He is called the deponent. Okay. The person who is making that affidavit, who is swearing that affidavit, is called the deponent. Am I clear? Is that clear? All of you? Am I clear to everyone? All of you? Any doubts? Any doubt? So you understood the meaning of affidavit. You also understood the person. What is the name of the person who makes that affidavit, right? Okay, fantastic. Great to see that. So guys, if you are liking this session, do press the like button. If you are liking today's session, do press the like button, guys. I'm moving on to the next question. A formal instrument, okay, by which one person empowers another to represent him legally. You are making a formal declaration whereby you are empowering another person to represent you. Is it called a will? Is it called a power of attorney? Is it called an affidavit, or none of the above? Very easy question. It's a very easy question. A formal instrument by which one person empowers another to represent him legally is called a power of attorney. So it is simply referred to as power of attorney. Power of attorney simply means an instrument, a document by which you are empowering another person. You are empowering another person to represent you legally. You are authorizing someone. You are asking, you are giving an authority to someone to do something on your behalf. Am I clear, everyone? Are you guys understanding? Okay. Moving on. To question number 7, right? Every dash years, the President of India reconstitutes the Finance Commission. In every how many years? How many years? Finance Commission, please give me the right answer. Okay. It is constituted every, very easy, every 5 years. Every 5 years, the Finance Commission is constituted. Am I clear? Is that clear? Is that clear, everyone? Every one of you. Okay? Every 5 years. Very good. So you are getting a lot of knowledge. Keep this knowledge to yourself. Keep this knowledge. You might be asked some similar questions. Okay, the next question. The historic Panchayati Raj Bill was adopted by the parliament by which constitutional amendment? So the constitution was amended to introduce Panchayati Raj system in India, right? So the Constitution of India was amended so that the Panchayati Raj system could be introduced. By which amendment? Which amendment are we talking about? Tell me that fast. Okay. 72nd amendment. Somebody is saying, okay. And the correct answer is not the 72nd amendment, beta. It is the 73rd amendment. I think it's the 73rd amendment. Okay. So do not confuse yourself. Okay. It's the 73rd amendment. So by virtue of the 73rd amendment, the parliament introduced the Panchayati Raj bill in India. Very, very important question for everyone. So Maharashtra CET, when you are preparing for SLAT, when you are preparing for JMI, these kind of questions do come. So do not just think that, okay, sir, ये जो पढ़ा रहे हैं वो कैसे काम के लिए आएगा. No. This is of great help to everyone. This will be of great help to everyone. Moving on. Question number 9. Which of the following is not one of the conditions to become a citizen of India? Which of the following is not one of the conditions to become a citizen of India? Please tell me the right answer. Now, to become a citizen of India, the law in India says that a person can become a citizen of India by birth. A person can also become a citizen of India by descent. If your father is an Indian, your mother is an Indian, then you become an Indian. Naturalization, if you stay in India for a particular period of time, then you can apply for citizenship and you can become a citizen of India. But can you become a citizen of India by acquiring property? Now, suppose a person who is a Canadian citizen buys some property in India. Can he tomorrow ask for Indian citizenship? Just by buying property, can you become a citizen of India? No, you cannot. So the correct answer is option D. Option D. Very good. Very good. Is that clear? Very good. Very good. Very good. The next question. When does the Comptroller and Auditor General of India retire? At the age of 65, after 6 years in office, 6 years in office, or 65 years of age, whichever is earlier, or both A and B. Which one? The Comptroller and Auditor General of India. What is the term of his office? The term of the office of the Comptroller and Auditor General of India is what? 65 years of age, 6 years in office, or C, 6 years in office or 65 years of age, whichever is earlier. Okay. The correct answer is 6 years in office or 65 years of age, whichever is earlier. For example, now suppose a person is appointed and let's retirement. Now suppose a person is appointed at the age of 50. He retires at the age of 56. Suppose a person is appointed at the age of 63. He retires at the age of 65. Am I clear? 6 years in office or 65 years of age, whichever is earlier. Very, very important. Whichever is earlier. Am I clear, everyone? Am I clear to each and everyone? Every one of you. Am I clear? So guys, if you're liking this session, what prevents you from just pressing that like button? There are more than 34 students who are watching me live. Okay, requesting all of you to just click on the click button. Okay, now click the like button. Okay, all of you. Chalo, moving on to the next question. Question number 11. Who is the executive head of the municipal corporation? The secretary, municipal corporation, the mayor, the commissioner, none of the above. The executive head of the municipal corporation. Is he called the secretary municipal corporation? Is he called the mayor? Is he called the commissioner? Or none of the above? And the correct answer is, let me see how many of you have given me the right answer. Some people are saying B. Sambhavi says C. Okay. He's called the commissioner. Oh, somebody saying A. Oh, Amulya Raj. But unfortunately, the correct answer is, he is called the mayor. The mayor of the municipal corporation, he happens to be the executive head of the municipal corporation. So, the municipal corporation is headed by the mayor. Okay? Option B is the right answer. Let's move ahead, everyone. Got it? The next question, question number 12. Who is the first law officer? The first law officer of the government of India? Please give me the right answer. The Chief Justice of India, the Solicitor General of India, the Attorney General of India, or the Law Minister? The first law officer of the government of India, Okay, fast. Okay, I am getting, is called Bisu Kumar says, okay, Attorney General. Okay, Attorney General. Some people are saying, okay, C. Okay. The first law officer of the government of India happens to be the senior most law officer of the country. And that person, the office is called the Office of the Attorney General of India. He is the first law officer of the government of India. He represents the government of India in the Supreme Court and the High Courts. He advises the government of India in legal matters. He gives his approval to various legal things that is happening with the government of India. And if the government of India has some question in their mind about a particular legal thing, it is asked to the Attorney General. Okay? That's called the Attorney General. Who is the Attorney General? R. Venkatramani. So Mr. R. Venkatramani is the Attorney General of India currently. Okay? Moving on to question number 13. Total number of schedules in our constitution. How many schedules? Okay, I think there should be an S. The total number of schedules in our constitution. So our Indian constitution has many schedules. Okay, we have the first schedule, second schedule, third schedule, fourth schedule. So how many total number of schedules do we have? How many total schedules do we have in our constitution? The sixth schedule, 6 total, 10, 8, 12. See, of late, I'm sure that you must have heard about the 10th schedule, which deals with anti-defection laws, right? Anti-defection laws. So, 6 and 8, though, you know that it can't be. You have heard about 10th schedule. So, 10. There are also 2 more schedules. The correct answer is 12. Total number of schedules is 12. Very good, very good. 12 schedules in our constitution. Very good. The next question. The Indian constitution recognizes minorities on the basis of what? Caste, color of the skin, population, religion. The Indian constitution recognizes minorities. The Indian constitution recognizes minorities on the basis of what? Caste, color of the skin, population, religion. Minorities in India. Okay, let's see the correct answer. Okay. Some people are saying A. Okay, caste. Dheeraj says C, population. Samaira Sultana says caste. Sambhavi Ghosh says population. Megha Patil says religion, D. Dheeraj says D again, religion. Harsh says population. Okay. So, under the Indian Constitution, minorities are determined on the basis of religion. The Christian community happens to be a minority community. The Muslim community happens to be a minority community in India. For example, more examples. The Parsi community, they are also considered as minorities in India. So, by virtue of the Indian Constitution, minority is determined on the basis of religion. So, what is the correct answer? Am I clear, everyone? Every one of you. Did you all understand? Okay. Any doubt? Any doubt? Any doubt that you guys have? Okay, fantastic. No doubts. Our next question. Question number 15. The Finance Commission is appointed every, I think this is the repetition of the question, so I'll not go into it. Sorry. Question number 16. Question number 16. Okay. I think there is some error in this question again. Question number 15. Let's check it. Who is the chairman of the Armed Forces Tribunal? The chairman of the Armed Forces Tribunal. The chairman of the Armed Forces Tribunal. Bishu Kumar says Ashok Bhushan. I think he is the chairman of the NCLT, National Company Law Tribunal. Ashok Bhushan. Justice Ashok Bhushan is the chairman of the NCLT. Okay. No, it is not C. It is not C. Meghna says D. Justice Ranjana Prakash Desai. No, she is not. Justice Arun Mishra is the chairman of the National Human Rights Commission. Justice Arun Mishra is the present chairman of the National Human Rights Commission. Yes, former Chief Justice of the Delhi High Court, Justice Rajendra Menon, is the present chairman of the Armed Forces Tribunal. So, former Chief Justice of the Delhi High Court, Justice Rajendra Menon, is the present chairman of the Armed Forces Tribunal. Okay? Yeah, absolutely. Justice Rajendra Menon is the right answer. Is that clear, everyone? So, guys, from these sessions, you will learn a lot of things. And that's why I request each and every one of you to please have a good understanding of these things. Okay? Our next question. What is the meaning of the term ad hoc? What is the meaning of the term ad hoc? A Latin term, ad hoc. Does it mean for a particular purpose? Does it mean at another place? A friend of the court in good faith? Okay, let's see. Somebody is saying at another place. Okay, what is the meaning of at another place? Alibi. Alibi. A friend of the court? Amicus. Amicus. A friend of the court means amicus. At another place means alibi. In good faith means bona fide. Ad hoc means for a particular purpose. For a particular purpose. Now, judges are appointed on an ad hoc basis also. Okay, there are too many pending cases for the purpose of these kind of cases, an ad hoc judge is appointed. So, for an ad hoc committee is appointed to look into a particular issue. So, for a particular purpose, if somebody is appointed, that is called for a particular purpose, ad hoc. Am I clear now, everyone? Everyone? Okay. So guys, if you're liking this session, do share this session. 18. The head of the defense forces in India. Defense Minister, Prime Minister, Army General, the President of India. The head of the defense forces of India. A very easy answer. Is a very, very easy answer. The head of the defense forces of India. It is not the defense minister, not the prime minister, even not the general of the Indian Army, but it is the President of India. The President of India is the head of the defense forces, Navy, Air Force, and the Indian Army. Okay? All the three. Okay. Correct answer is option D, the President of India. Question number 19. What is the qualification of obtaining voting rights in India? What is the qualification of getting voting rights in India? Is it property, education, age, all of the above? We are talking about adult franchise. What is the qualification for obtaining voting rights in India? It is age, 18 years of age. Okay, so the qualification is if you are 18 years of age, a citizen of the country, you can get voting rights in India by, of course, registering yourself with the Election Commission of India. Okay. Okay. Next question. Where is the seat of the High Court in Uttar Pradesh? Lucknow, Allahabad, Kanpur, none of the above. The seat of the Uttar Pradesh High Court. Lucknow, Allahabad, Kanpur. Okay, what is the capital of Uttar Pradesh? The capital city of Uttar Pradesh? How many of you are from Uttar Pradesh? Tell me that. How many of you are from Uttar Pradesh? The capital is Lucknow or Prayagraj, but the High Court sits at Allahabad. The High Court, the seat of the High Court is Allahabad, the Allahabad High Court, right? All of you? Great. Chalo. Let's move on to the next set of questions, and those will be all principle and fact based question. So read the principle, read the facts, and give me the right answer. Okay, read the principle, read the facts, and give me the right answer. Now, the principle of conspiracy is provided when two or more than two people commits a criminal act in furtherance to a common intention. What is the common intention in this case? To kill Mr. C. Then all such person, then each of such person is liable for the act in the same manner as if it was done by him alone. So everyone will be held liable. A and B conspires to kill C. A buys the poison, B mix it in the drink, C dies. What is the correct answer? Tell me. Read and tell me. I want every one of you to give me the right answer. Absolutely correct. Absolutely correct. Both A and B has committed the offense of murder. Option D. Both A and B has committed the offense of murder. Okay. Very simple. Question number 22. No person shall be prosecuted and punished for the same offense more than once. Now, here is Mr. A, who was found harassing some female colleagues in office. So, A filed a criminal case against him, and he was held guilty and to undergo 2 years of imprisonment. After serving his punishment, the posh committee of the company found him guilty and fired him. Now, is he being prosecuted twice? He is prosecuted only in a court of law. You cannot prosecute someone. Now, this is a departmental thing. What the company is doing is not punishing, it's a departmental inquiry, finds him guilty and fires him. Is that clear? Every one of you. Did you all understand? This is not a case of double jeopardy. This is not a case of double jeopardy. The decision of the committee is valid because it does not amount to second punishment. Is that clear? Is that clear? Option A is the right answer. Everyone. Next question. Question number 23. Right against self-incrimination. Nobody can be forced to become a witness against himself. Very, very important. Look at the principle. The court directs Mr. X to come to the court and provide his signature. X says, no, I am not going to do that. Just stick to the principle. Just stick to the principle. Just stick to the principle. Let's see the answer. By calling upon Mr. X to give signature, the magistrate has compelled him to be a witness against himself. Read, no person accused of an offense shall be compelled to be a witness against himself. The court has asked Mr. X to provide his signature, and his signature is in dispute. Am I clear? Now, I can understand a lot of you might have a lot of question in their mind. Now, you are preparing for CLAT. There are other laws also. Now, you are not taught law of evidence and all. So, based on your limited understanding of the law, option A is the right answer. Option A is the right answer for Maharashtra CET, SLAT, and other exams. Okay. The answer might be different in real life, might be different. So, we are just thinking about your entrance examination. So, keep that in your mind. Okay. So the real law might be different, but since you are only to understand only based on certain principles, that's it. So limit yourself to that. I hope I am clear, right? Question number 24. there shall be equality in opportunity for citizens in matters relating to employment. But the state can make any provision for the reservation of appointment in favor of any backward classes of citizen, which in the opinion of the state is not adequately represented in the services. The government of a state comes up with a law which provides reservation of 20% of for people belonging to Y community, which is a backward community. As per the opinion of the state, the community is not adequately represented in the services. Mr. A belongs to Z community, files a writ and says that the law says equality of opportunity. But this man forgets that this law has another clause which says that the state can make a provision for reservation of appointment in favor of any backward classes of citizen, which in the opinion of the state is not adequately represented. Am I clear? 24. Is the law valid? Is the law not valid? Is the law valid? Is the law not valid? That's a precise question. A very simple question. The law is valid. The law is valid because the principle empowers the state to make reservation for backward classes if it is in the opinion of the state that particular community is not properly represented in that services. Am I clear, everyone? So guys, if you are liking this session, do press the like button, do subscribe to our channel, and do not forget to press the follow button, okay? And do press the ring bell also so that we will provide you with notifications of our upcoming classes. Okay. Moving on. Next question. Question number 25. Read the question very carefully. The principle over here simply says that the state shall not make any law. State shall not make any law which takes away or abridges, which violates the fundamental right. And any law made in contravention, any law that is made which is violative of fundamental right shall be declared void. Am I clear? So there is a prohibition on the legislature from making any law that violates the fundamental right of a citizen. Right. The government of X came up with a law which made double jeopardy legal and valid. Wow. So law says that a person can be punished twice for the same offense. Right? So a law is made which simply says that a person can be punished twice for the same offense. Very well. Therefore, a person can now be punished twice for the same offense. The law has been challenged in the court. The court held that this is void. From the option given below, provide which of the following reason will justify the Supreme Court's judgment. Am I clear? See. A law that is violative of the fundamental rights of a citizen can be declared void by the High Court or by the Supreme Court. The High Court can do it under Article 226. The Supreme Court does it under Article 32. So that is called the writ jurisdiction, right? There are 5 different types of writs, mind you. So the correct answer is the law is inconsistent insofar as our fundamental right is concerned. Right against double jeopardy. Am I clear? You cannot be punished twice for the same offense. And the legislature cannot make such a law. Because there is a prohibition on the legislature that you cannot make a law that is violative of a citizen's fundamental right. Okay? Is that clear? Any doubt? Any doubt? Any doubts that you have? Very good. Everyone. Very good. Okay, moving on to the next question, question number 26. Okay, read the question very carefully. Nice question. So the law simply says that a child below the age of 14 cannot be employed. A child below the age of 14 cannot be employed in a factory, mine, or engaged in any hazardous employment. A 12-year-old boy can help his father in a chai shop. There is no difficulty about it. But there is a prohibition of a child below the age of 14 insofar as working in a factory, mine, hazardous employment is concerned. So the question is, 7-year-old child, he was working in a pesticide plant. Is it hazardous? It is not a mine, not a factory, it's a plant. Is the child working in a pesticide plant is doing a hazardous employment? Yes, of course. That is the right answer. Absolutely, every one of you have given me the right answer. Pesticide company, pesticide plant, poisonous, glass factory. That's also hazardous employment, right? The correct answer is option A. Is that clear? All of you? I hope everyone is with me on the same page. Don't fall off to sleep. I know it's a Friday and it's close to 9 p.m. So let's not fall off to sleep. Okay, question number 27 is up there on your screen. Subject to public order, morality, and health, all persons are equally entitled to freedom of conscience, freedom of religion, freedom to freely profess, practice, and propagate religion. A people belonging to X community filed a PIL in the Supreme Court to prohibit people belonging to Y community from wearing black color while offering prayers in their locality, because the X community people consider black as color of evil. So there are two communities, X and Y community. X community thinks that black is evil, and Y community feels that black color is lucky, it's godly. So Y community people go and pray in black clothes. X community people goes to the Supreme Court and files a PIL. Now you have to decide. Wearing black cloth as was an essential practice of Y community. Now you have a right to freely profess, practice, propagate your religion. Two different communities. Now, for example, the Hindu calendar is based on the sun. The Muslim calendar is based on the moon. Very good. No problem at all. Now, can tomorrow a Hindu go to the Supreme Court and say, no, 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 please stop Muslim people from following the moon? Or can tomorrow a Muslim person go to the Supreme Court and say, ask the Hindu community not to follow the sun? Hilarious. Hilarious. Please tell me the correct answer. People are saying B. Okay, B. Both B and C. Okay, the correct answer is option D. B is definitely right. And every person has a right to freely profess, practice and propagate religion given in the principle. So the correct answer becomes option D. Am I clear? Just do not read the second option and stop. Read the third option. Read the fourth option also. Am I clear? So the best answer is both option B and option C. That is option D. Is that clear to everyone? Is that clear to everyone? Tell me that. Okay. Everyone? Any doubt? No. Beautiful. Brilliant. Moving on to the next question, question number 28. Read it carefully. The principle deals with abatement, the offense of abatement. What does it mean? A person abates an offense who abates either the commission of an offense or the commission of an act. It would be an offense if committed by a person capable of the law committing that offense with the same intention and knowledge of the abater. Now, for this principle, you need to know what is abatement. If you are helping someone in the commission of a offense, that is called abatement. If you are instigating an individual, if you are helping someone, if you are aiding someone in the commission of an offense, that is called abatement. A and B were friends. Difference arose between them. When B refused to return A's money, C, who was A's wife, asked A to take revenge from B. She arranged a gun and gave it to A. A shot B, who survived the attack. Is it a case of abatement? Please tell me the correct answer. A and B were friends. They had certain differences. A's wife, C, helps A in the commission of murder. Did not commit, of course. He survived that murder. So under these circumstances, Under the present circumstances, which of the following is the best answer? A has committed what? Attempt. And C has committed abatement. Am I clear? Am I clear to everyone? A has committed attempt to murder. He survived. He survived. Am I clear, everyone? All of you? So guys, this session is important for everyone preparing for Maharashtra CET, SLAT, JMI LAW, as well as other law entrance examination. Pay a lot of attention. Share this session with your friends. Okay. So the correct answer is option B. Moving on to question number 29. I'm sure that those of you who have read the Gloucester Grammar School case, will solve the question within seconds. And I'm sure that most of you have read it. Only in case there is a violation of a legal right, you can go to the court and claim compensation under law of tort. So, under law of tort, in case your legal rights have been violated, only in case your legal rights have been violated, जब कभी आपका अधिकार का हनन होता है, तभी आप कोर्ट के पास जा सकते हैं, तभी आप कोर्ट से कॉम्पेंसेशन दावा कर सकते हैं. So, over here, A has a music school, charges 10,000 rupees a year. B sets up another music school opposite to A's school, charges 7,000 rupees. So a lot of student leaves A's school and joins B's school. A suffers financial loss. Now, the question is, has B violated A's right? Has B, the question is, has B violated A's right? No, he has not. So, unless and until there is a violation of a legal right or an infringement of a legal right, you cannot ask for compensation. So, the correct answer is, although there was a damage, there was a loss, there was no violation of a legal right. Am I clear? There was no violation of a legal right. Am I clear to everyone? Is that clear, everyone? There is a loss, there is a damage, but without lawful injury. Right. Okay. Chalo. Question number 30. Question number 30. any direct physical interference with goods in somebody's possession without lawful justification is called trespass. A has purchased a sofa from B. Now D believes that the sofa was his and he removes it from A's house. Is it a trespass? Yes, this is what we understand as trespass. Now, in civil law, your intention does not play a role. In criminal law, intention plays a role. Okay, so do not be confused. Okay, everyone. In criminal law, your intention plays a role, but in civil law, there is no role of intention. All of you, am I clear? So are you guys understanding? Good, good. Let's move ahead to question number 31. Shabrimala. There's a judgment of the Supreme Court relating to the Shabrimala issue. That's the biggest hint that I can give you in so far as question number 31 is concerned. Now, untouchability is defined and abolished under the Indian Constitution. Nobody shall be considered untouchable. Everyone is equal. Now, there is a village which is infamous for various inhuman practices concerning women. And what is one of those practices? One such practices is refusal to touch any woman during their menstrual cycle. Miss Pratima, a human rights activist, challenges these practices of that village. Now, what was that Shabrimala issue? A woman between the age of 10 and 58, 60 were not allowed inside a particular temple. So there were women between a particular age group who were not allowed inside a particular temple. Very good. Now, this practice was challenged before the Supreme Court. The Supreme Court, by a constitution bench, held that this practice is bad. First and foremost, this practice is bad because this means untouchability. Untouchability under the Indian Constitution has been abolished. Has been certainly abolished. Now, if you have a system which is akin to that, woman between a particular age group, why? The reason behind it is that they were having menstrual cycle. Fair thought. Now, does it mean that a woman who is having a menstrual cycle becomes untouchable? Yeah, please give me the right answer. Is the practice valid, invalid? Okay, the correct answer is the practice is against the law of untouchability. So the correct answer is option A. Is that clear? The practice in that village is opposed to the law, and hence the Supreme Court can declare it unconstitutional, this particular practice. Shabrimala temple, I'm sure most of you are aware of it. Okay. Moving on to question number 32. Please read the question. No person shall be deprived of his life or personal liberty except procedure established by law. A kidnapped B, kept him in a house for a week, refused to give him food and water, and B dies. has B deprived A of his right to life and personal liberty? Now you can deprive, if someone is arrested by the police, police can arrest a person based on certain procedure. Now kidnapping is not the law. Is kidnapping the law? No, it is not. So the correct answer over here is A. B has deprived A of his right to life. B's right to life has been deprived. B's right to life has been deprived because A has, kidnapped him without food, without water to drink, and as a result, A dies. B dies. Am I clear? I hope everyone understood this. Great. Chalo, to the next question, 33. A contract is an agreement enforceable by law. All agreements are contracts if they are made with free consent by parties eligible to enter into an agreement and for a legal object. A offered to sell his bike to B for 5 lakhs. B denied the offer, which made A furious. A decided to kill B and pointed a gun at his head. In the fear of death, B consented to the deal. Free consent. Now, if you keep someone a pistol on someone's head and you tell him buy my product or sell, is it a valid contract? The question is it a valid contract? The contract is it a, this is not with free consent. So the correct answer is not enforceable in the eyes of law. Is that clear, everyone? Because it was not done by way of free consent. It was not done by way of free consent. Am I clear, everyone? Okay, everyone? 34. Whoever intending to take dishonestly any movable property out of the possession of a person without that person consent moves that property has committed theft. Read the facts. So if you are intending to take a movable property out of the possession of a person without his consent and you move that property, that is called theft. Am I clear, everyone? All of you? Any doubt? Am I clear? Is that clear, everyone? A hint, tricky. If you take someone's movable good outside the possession and ownership of that individual with the intention of taking it, you move it, that is called theft. And the correct answer, let's see how many of you got it right. B, everyone. Oh, Shambhavi, don't spam. Please, don't spam like that. Somebody is saying A. Okay. Arushi. Okay. Okay. The real question is, read the principle once again. Read the principle once again. Read the facts once again. Intending to take dishonestly. Here was something that was entrusted to B. A was going out of town, so he decided to give his cat to B. It was entrusted upon B. So the correct answer over here is am I clear? Am I clear to everyone? All of you. Yash, you might call it. So let's not get into breach of trust right now. Let's not get into breach of trust right now. Okay. Okay. 35. Read the principle very carefully. Now, suppose I say I want to sell my pen for rupees 100. You say I will buy the pen provided you sell your pencil also. Have you accepted my offer? Have you accepted my offer? That's a precise question. I say I want to sell my pen for rupees 100. You say I will buy your pen for rupees 100 provided you sell your pencil for rupees 2. Is it a valid acceptance? Is it? Tell me that. Am I clear? Have I made myself clear? Is that clear to everyone? The correct answer is it has not been converted into a promise, because the principle says that the acceptance must be the mirror image of the proposal. Here the acceptance is not absolute or unqualified. It has certain terms and conditions attached. There are certain terms and conditions attached to the acceptance. Am I clear? Everyone? Okay, all of you? Brilliant. Moving on to question number 36. Okay. Master or principal is vicariously liable for the tort or the wrong committed by the servant or the agent in the performance of his duties as a servant or agent. A and B were neighbors. A was a pilot and B was a cashier in Citibank. A invites B for a lunch and gives some money to be deposited in the bank. Instead of depositing A's money, B misplaces it. Will the bank be held liable? Now, when we are discussing about the principle of vicarious liability, it must come to your mind that has the bank authorized its cashier that you can have a friend, you can go to your friend's house and collect some money and deposit it in the account? They were neighbors. It can be at best breach of trust. At best, it can be a case of breach of trust. But can it be said that the bank is liable right now? Can it be said? Let's see. The Citibank will not be held liable. The Citibank will not be held liable. Am I clear? Okay. Everyone got it? Who does it? All of you. Everyone. Is that clear? Any doubts? Okay, good. 37. Now, the principle simply says that no person who is arrested, he should be informed why he has been arrested. So, when the police is to arrest an individual, it is the duty of the police to inform what are the grounds of such an arrest. A understands Hindi. The police officer informs the ground in Sanskrit. The police officers further refuse to provide grounds in the language that A understands, that is in Hindi. A is in custody. Now the question, amongst the four options, which of the option is the best answer? Very good. A has a right to be informed the ground of arrest, which has been denied to him. Am I clear, everyone? Is that clear, everyone? Most of you got it right. All of you. Very good. Congratulations. Bingo. Lovely. Very good. So your preparation is good. But these are not very difficult questions. These are all moderate level questions. Easy to moderate, which generally comes in Maharashtra, CET, SLAT, and other examination like JMI and all. Right. 38. एक दिन के लिए मिस हो गया. Hint. Marriage can be between two Hindus under the Hindu law, provided that neither of the parties has a living husband or a wife at the time of marriage. A and B was married for 14 years. Doctor told A that she is suffering from the final stage of cancer and has only 2 days left. In order to ensure the well-being of her husband and children, the dying lady on the deathbed asked B to marry A's sister C immediately. Accordingly, B married C and A died after 1 day of their marriage. During when your wife is alive, are you eligible to marry someone else if you don't get a divorce? Am I clear? Everyone. Please give me your answers fast. The marriage between B and C is not valid because the wife was alive. The wife was alive. The wife was absolutely alive on the day. And what does the principle say? What does the principle say? Let's see. Let's check out that. If neither party has a spouse, if neither party has a spouse, एक दिन के लिए खत्म. Am I clear? Have I made myself clear? So now these are pretty tricky things, okay? You might feel that, oh ho sir, cancer से मर रही थी, अपना बच्चे को संभालना चाहती थी. No, read the law. Do not fall under those emotions. All of you. Okay. Chalo. Moving on. The next question, question number 39. Read the question very carefully. All citizens have a right to freedom of speech expression subject to reasonable restriction. And the restriction can be in the interest of sovereignty, integrity of India, security of the state, friendly relation with foreign states, public order, decency, or morality, or in relation to contempt of court, defamation, or incitement to an offense. So, you have certain freedoms. There are certain freedoms which are provided under the Constitution, but these are not absolute in nature. They are subjected to interest of the sovereignty, integrity of India, security of the state, friendly relation with foreign states, public order, decency, morality, relation to contempt of court, defamation, or incitement to an offense. Please read the facts. Now, the legislature has passed a law, is passing a law called the Porter's Bill. Now, the newspaper published certain articles on the Porter's Bill, which was being criticized by porters, and various riots and violent protests took place across the country. Now, owing to this, the court directed the publisher not to publish anything because of the sensitivity of the matter. Now, X approached the Supreme Court and said that his freedom of speech and expression is being violated. Am I clear? Is that clear? Read the facts once again, all of you. All of you, once again. Yes, the options. Now, during the farm law protest, now there were three bills, the farm laws protest that was happening around 2 years back. Now, can a journalist be asked to stop writing about a particular law which is passed in the parliament? Don't we have a right to debate? A section of the people, there might be protest. Think and tell me the answer. Okay, let's see, please. Yeah, a lot of people are saying A. Okay, somebody saying B, somebody saying C. Now, restriction. Now, none of your freedoms are absolute, I understand that, but it's a journalist's right to freedom of speech and expression. Now, you cannot, now, some movie shows something and a section of the society is not happy with it. There is some protest. Fair thought, but don't I have my freedom of speech and expression? Let's see the correct answer. X's freedom of speech and expression is being violated. Now, that is the trial court's order is wrong. Now, this is not a different issue. This is a law that is made by the legislature. A law that is made by the legislature. I have a right to give my opinion. NRC, CAA, no problem. You write an article on CAA. Some people might sit on protest. Does it mean that you stop writing? Am I clear? Everyone. Am I clear to everyone? Did you all understand? Okay. So guys, if you are liking this session, do press the like button. Do press the like button, guys. Okay. Okay. So that's all that we had for today. But BYJU'S Exam Prep brings to you a comprehensive course for CLAT 2024. In this course, we provide you with 300 plus recorded videos, 300 plus hours of live classes, 35 mock tests for CLAT and non-CLAT exam along with video solutions, monthly e-magazine on your current affairs, and the entire content is based on our analysis of the last years of CLAT question paper. So hurry up and register yourself if you are appearing for CLAT 2024 for this comprehensive course. BYJU'S Exam Prep brings to you a free workshop on why choose CLAT as a career on 9th of April at 6 p.m. This free workshop will be conducted by Nivedita Raje. So hurry up and register now today for this free workshop. So guys, if you like today's session, do press the like button, do subscribe to our YouTube channel, do follow us on our Instagram, do like our Facebook page, do join our Telegram channel, and just do not forget to download the BYJU'S Exam Prep app today itself if you have not done it till now. So guys, with this we come to the end of this session. Thank you very, very much. God bless you. All the best. Have a great weekend ahead. That's all that I had for you today. Good night. Bye-bye. Take care. Bye-bye. And I hope you enjoyed today's session. See you soon with another interesting session. Bye-bye.